So, the discrimination claim, my lady, the EU law discrimination claim, that's issue 1 in the Statement of Facts and Issues, Mr. Drabble's made clear is based entirely on Article 21 of the Charter of Fundamental Rights. We say, as you know, that the Charter is not applicable in this case because the regulations under challenge are not implementing EU law within the meaning of Article 51, subparagraph 2 of the Charter. And we rely on the reasoning in cases such as Ida and Imaraga that we looked at before lunch as to how the court approaches the question of whether a member state is implementing EU law, and also approaches it on a narrow basis, we submit. So 3 particular reasons why the United Kingdom is not implementing EU law in the Charter sense through these regulations. The first reason is the point made by my Lord Carnwath and supported by the reasoning in the Imaraga case that I showed you earlier on, paragraphs 42 to 43, MS 1858. And that is the point that once paragraph 42 of Zambrano is satisfied and there is no threat to the genuine enjoyment of the right to live in the EU, as it is accepted there isn't in this case, it follows that anything further that the member state chooses to do in this general area is not governed by EU law. It's a matter of gold plating, as Lord Khan put it. So that's the first point, squarely supported by the reasoning in Imaraga. He was outside Zambrano, therefore outside the scope of the Charter as well. Second reason, if one wishes to descend into detail and apply the criteria which one finds in paragraph, I think it's 40 of Imaraga and the equivalent paragraphs of Ida, it is clear from those criteria that these regulations do not implement EU law. So first criterion, are the regulations intended to implement a provision of EU law in the technical sense? Well, no, they are not. On the contrary, they are intended to confirm that a newly discovered rule of EU law in Zambrano did not affect the pre-existing position of third country nationals. Secondly, do these regulations pursue objectives other than those which are covered by EU law? Well, absolutely they do, and see the objectives adumbrated by Mr. Cooper in his witness statement, matters such as immigration control and the fair allocation of resources between different groups in society. These are squarely within the compass of member state action and not objectives of the EU. And thirdly, are there any specific rules of EU law on the matter capable of affecting these regulations? Well, no, there are not. And any specific rules in the area, we say, and I've shown you the secondary legislation, the long-term residence directive and so forth, all of the secondary legislation suggests that this is not a matter for EU law at all. It is for member states to decide what social benefits to afford to third country nationals. So if one does want to go into the criteria in any more detail, well, that is the answer. The third reason, though, why we are outside the scope of EU law for Charter purposes is that national rules which lay down criteria for the allocation of social assistance and social security benefits are not, as a subject matter, are not within the scope of EU law for charter purposes. Now, that is a point that we make in paragraph 36 of our case. And 36, paragraph 2 in particular, and we make it with reference to the conclusion in paragraph 91 of Dano, and it really couldn't be any clearer than we've set it out in that paragraph. When the member states lay down the conditions for the grant of special non-contributory cash benefits and the extent of such benefits, this is paragraph 36, subparagraph 2, they are not implementing EU law. Now, if I could ask you to take up Dano, as I just need to answer a point that Mr. Drabble made, and it's bundle 1B, tab 17, and it's MS 1495. So the 1495 at the top is the paragraph that we've quoted from in our printed case, paragraph 91, that sets out that very clear conclusion. One can see the questions which the Court of Justice was asked by the National Court on 1488. They were somewhat caricatured by Mr. Drabble, who said, well, first of all, the Court of Justice had to decide whether there was any EU law right to these benefits, and once it had decided there was no EU law right, there was no issue under the Charter either. Well, that's not quite doing justice to the questions that were asked. Paragraph 45, you see the questions of the German court. There was firstly a question on Regulation 883 on special non-contributory benefits. But then the second question was whether Regulation 883 on coordination of social security systems required the payment of benefits to people in the position of the claimants. The next question, 3, was whether Article 18, non-discrimination, or Article 24 of the Citizenship Directive 2004-38, whether they provided for a right to benefits for the claimants. And then, in the event that those questions were answered in the negative, so the claimants had no right under those provisions of EU law, well, could the Charter step in, paragraph 4, at the top of 1489, could the Charter step in to guarantee, you see there, a level of subsistence which was not limited to the provision of funds for return to the home state? So do Articles 1, 20 and 51 of the Charter require more extensive payments which enable permanent residence? And actually quite a similar claim to what the claimant makes in this case. She doesn't want the bare minimum. She wants a quantum of payment, a more extensive payment to facilitate permanent residence. So that was the question 4. And having answered the second and third questions in the negative, so no rights to benefit under 883 or the Citizenship Directive or Article 18, because the claimants were not economically active, etc., etc. Then you get question 4, does the Charter help instead, paragraph 85 onwards? And the reasoning, we say the very clear reasoning in 89, 90 and then 91, is that the member states are simply not implementing EU law when they lay down the conditions for the grant of these subsistence benefits.
And of course, Mr. Drabble brought our attention in particular to the last sentence of paragraph 73, which was the conclusion of the ECJ, as it then was, that there was no EU requirement for an economically inactive union citizen, other than that she should have sufficient resources.
Yes.
And Mr. Drabble says you've got to read 91 in that context, whereas he says in our case, it's the whole issue is what EU requires.
Yes. Well, he's wrong about that. 73 is part of the reasoning on the question: is there a right to benefits under the Citizenship Directive, through the right to equal treatment under the Citizenship Directive? Answer: no, because Article 7.1b of the Citizenship Directive requires self-sufficiency as a condition of the right of residence. If you're not self-sufficient, no right of residence, no right to equal treatment, you can't get your benefits under the Citizenship Directive. That's the answer to question 3.
Yes.
But then a separate question: can the Charter help us in any event? Separate question, answer: no, it can't, because this whole area of deciding who shall get subsistence benefits and who shan't is not within the scope of EU law for Charter purposes. So I can see why Mr. Drabble wants to muddy the waters in this way, but it's really very clear. There are certain questions are answered, and then there's a Charter question at the end. Now, the finding that the rules of entitlement to social assistance, the cash benefits at issue in Dano, a similar finding was made in Commission against the United Kingdom in relation to child benefit and child tax credit. And I make that point because I know my lady queried yesterday whether the position might be different for the family benefits as compared with the other welfare benefits governed by these regulations. And the answer in part is, well, they are categorised in a different way under EU law. They are family benefits, they are social security rather than social assistance. But the same conclusion as was reached in Dano was reached in this case. It's 1B, tab 16, so it's the same bundle, tab 16, paragraph 65, MS 1446. And yes, it's 65. On the other hand, that provision, as a provision of Regulation 883 in that case, was not intended to lay down the conditions creating the right to social security benefits. It is in principle for the legislation of each member state to lay down those conditions. See Bray and Dano, paragraph 89. That's what we've just been looking at. So it's not just the social assistance, classic welfare benefits. It's also child benefit and child tax credit, social security benefits. And of course, the result of the Commission against the United Kingdom infraction case was that the right to reside test in relation to child benefit and child tax credit was compatible with EU law. And the result of that is that many EU citizens living in this country will not qualify for child benefit where they're not economically active. So it's the same position as to scope of EU law for child purposes as under Dano. So it couldn't be clearer in our submission that this subject area is outside the scope of EU law for Charter purposes. Now, if Mr. Drabble was able to overcome that a priori obstacle to reliance on the Charter and to Article 21, there then follow in our submission a variety of further difficulties with the discrimination claim. And that is paragraph 38 onwards of our printed case. And I'm going to focus a little bit on the case now, just for speed. Paragraph 38 onwards, having argued the point about scope and whether the Charter applies at all, we then in 38 move on to grounds of discrimination. Mr. Drabble says his ground of discrimination under Article 21 is immigration status, other status, immigration status, he says.
Well, actually, what he said when I asked him about it was Zambrano status.
Well, all right, that particular immigration status. But starting from the premise that he cannot complain about discrimination against third country nationals, see Article 18, see the permission hearing that we had and the deletion of that point from the grounds of appeal, can't complain about discrimination against third country nationals. He cannot then, we say, complain about discrimination on a ground which is inextricably associated with third country nationality. And of course, Zambrano status can only be held by a third country national. If you're an EU national, you can't have a Zambrano right because you've got somewhere else to go in the EU. So it's only
Can one discriminate against children on account of the immigration status of their parent?
Well, we say that's a further difficulty.
Well, I mean, I'm not sure who it's a difficulty for. I understand that you are saying this particular head of discrimination focuses strictly on the status of the carer because she is the only person who can be a Zambrano carer. Is this not? Can you not discriminate against children, not on account of any characteristic of theirs, but on account of a characteristic of their parent? Because if so, it may well be that the point that you make about the only Zambrano carer being HC doesn't go anywhere.
Well, my Lord, there was an interesting debate before Mr. Justice Supperstone, which you'll see in the judgment, as to whether associative discrimination was a permissible ground of complaint. We don't need, and he said, not in this case, we don't need to go back into that. The answer, I think, to my Lord's question is it wouldn't help. If I'm right, and if I'm right, that complaining about discrimination on grounds of Zambrano status of the carer is inextricably linked with third country nationality and so not a permissible ground of complaint, then it doesn't help to recast it as a complaint by the child about discrimination on grounds of his mother's immigration status, which is inextricably linked with third country nationality. It's the same problem in our
Well, I'm not entirely sure that it is the same problem, because you are the discrimination. The victim of the discrimination on that hypothesis is somebody who is admittedly indirectly affected by the status of another person, and it may not be an answer to say, well, the carers got no complaint. The carer's absence of complaint, if that be the position, is closely associated with her own particular status. But that is nothing to do in the relevant respects with the problem that the discrimination or alleged discrimination poses for the children.
Well, Lord, I understand the point, but it is entirely the same problem as is being suffered by the carer. So let's put it more simply. Take out the Zambrano additional complication. Let's say the carer's complaint was, I'm a third country national, I'm excluded from benefit by Section 115 of the 1999 Act. That's contrary to EU law. Answer, no, it's not, because Article 18 makes clear that third country nationals have no right to equal treatment under EU law. That's undoubtedly correct. Would it help then for the child to say, well, hang on, my mother might not have a claim, but I can complain that I'm being discriminated against on grounds of her third country nationality, or I'm being adversely affected by discrimination on grounds of her third country nationality. It's the same point and the same answer, which is that's not a type of discrimination which EU law prohibits, and it would be bizarre, frankly, if it was. I mean, that would be a very easy way to sidestep a very important principle of EU law.
Well, it might not prohibit it on the basis that that effectively the discrimination was against the child by comparison with other British national children, but the answer to that may well be that EU law does not prohibit discrimination as between different categories of a member state's own nationals. But that's not an argument that would help you on Article 14.
Well, yes.
I know you're not on Article 14, but all of these points have knock-on effects on other aspects of the case, which is why I think one has to think about them globally.
Indeed, and it is a further problem with the argument when put in terms of the child as to which children are we comparing with.
Yes. Well, I understand your point about the comparison with other people who equally have no rights, but the position as between different categories of British children may be somewhat different.
Well, I mean, certainly it is, and looking at our table, it is the case that a British child of a British parent will have benefits in circumstances where, or the parent will have benefits in circumstances where a third country national parent.
Relevant, I think you accept not so much under EU law as under the Convention. If it's relevant at all, that's the heading, the Convention.
Yes, that would be, yes. I mean, there are insuperable obstacles as a matter of EU law. There are other problems under the Convention that I'll come on to.
Mr. Coppell, if we are at the stage of looking for a comparator, then taking up your helpful table, are you arguing that it's the third box down, economically inactive EEA national with a British national child, which is the best comparator, or not?
No, I'm saying the best comparator, I mean, that's a possible comparator. I'm saying the best comparator is the TCN with no EU law rights. So let's take...
But with a British national child?
Yes, with a British national child, exactly.
And Lady Hale said, well, let's just think about that.
Yes, so
why aren't 99% of them Zambrano carers?
Well, I mean, there are lots of reasons why they may not be Zambrano carers. Let's take one reason, and it's the other viable carer. It's the other parent who is a viable carer for the child in the event that the mother has to leave the country. Let's take that situation. It's as close to Zambrano as you can get without being in Zambrano.
In other words, without having dependent children who need that person to look after them, which is a rather large difference. If we look at it from the children's point of view.
Sorry, lady.
You're saying that the best comparison is a TCN with British national children, but no EU law rights. And the best example that you can give, I agree with you, is it's where there is somebody else who can look after the children.
Yes.
Well, then we are not in a situation where the children are deprived of proper care and proper support and are at risk of being forced to leave the EU. So we're not in the situation, it's nowhere near the situation we're in here, what I'm trying to say.
Nobody is being forced to leave the EU. That's what the Court of Appeal found.
Yes,
that's the starting point
that's
for this
a separate
case.
Point.
Nobody's being forced.
Suppose they had not found that.
So Lady, I'm sorry, that it's important that they did find that, so there is no risk of HC being forced to leave the EU. The closest comparator to HC's situation is another third country national with 2 children like her, whose other parent is a viable carer in the event that person has to leave. Now those children may be dependent on the mother, as HC's children are, but they can be viably, practically looked after by somebody else. See Chavez, that's as close to Zambrano as you get without actually being within Zambrano. Take another example, is the carer who has a right of residence in another EU country, who can go to, if they have to leave the UK, can go to France. They may have all kinds of reasons for not wanting to leave the UK, all kinds of reasons why they want more state support while they're here, but they don't get it. They're not Zambrano. They're standard third country national, British national child, section 115 of the Immigration Act. And it's unfortunate that we're having this debate orally in circumstances where Mr. Drabble has avoided pinning his colours to the mast throughout this case, right from the, well, it was Mountfield first I was complaining about, and then Mr. Drabble when he took over. All that he's done is to trot out the incorrect mantra that there's a special category of UK national children being created who are in a completely different position from other children. Not the case. And we're now having to have this debate about who the best comparators are. Those are the 2 best examples I can give, as close as possible to Zambrano, not Zambrano, no benefits, no mainstream welfare benefits. So paragraph 39 of our case, it contains a few different points, some of which along the lines that we've just been discussing. So first of all, who are the right comparators here? And I've just been arguing about that. And secondly, is there unequal treatment between HC's children and the comparators' children? See the table. No. The next, I think, a further point that's contained within paragraph 39 is the second sentence, and we say the position of a person with a Zambrano right is not comparable to that of a person with a wholly different right of residence. Now this point answers a point that Mr. Banner made in his printed case, where he says, well, the Zambrano right, it looks a bit like the Ibrahim Tejera right. It's a bit like that. It can be held by third country nationals. They have children. They can stay here during the currency of the education, and they can claim benefits. So why shouldn't the Zambrano carer be able to claim benefits? And on that kind of argument, the court is placed in what we say is a very difficult position of having to compare different rights of residence which have different EU regimes attaching to them, and to somehow weigh up which is the closest and which ought to have which level of benefit attached. Now, if you look at the Ibrahim Tejera right, it's one can see it in paragraph 7 of Tejera. If we just have a look at that, bundle 1C, tab 19, paragraph 7. You do have the legislation in the bundle as well, but let's just look at it in the case. 1588, MS 1588. It's paragraph 7 at the top, and it's essentially a right of the children of a national of a member state who is or has been employed in the territory of another member state shall be admitted to that state's general educational, apprenticeship, vocational training courses under the same conditions as nationals. If such children are residing in its territory, member states shall encourage all efforts to enable such children to attend those courses under the best possible conditions. Now, a number of reasons why this right is quite different from the Zambrano right. First of all, it is a right which originates from the free movement of workers. Section 1268 was the workers' rights regulation, and the starting point for it is an EU national who does the best thing so far as EU law is concerned and moves to another country to work. Various rights come with that, including the right to install your children in the host country with you and for them to attend education. So that's the starting point. It's the top right, the workers' right, which gives rise to these subsidiary rights for the children. The right is primarily directed at EU nationals, of course. It's EU nationals moving from one state to another with their families. Now, of course, it is the Court of Justice expanded upon the legislation to say, well, the right of the child of the EU national to attend school under the best possible conditions means that his parent has a right to live in the country with him, and his parent may be a third country national, as Ibrahim was. Tejera wasn't. Ibrahim was, but it is primarily directed and primarily held by EU nationals. And as a right which derives originally from free movement of workers and all the panoply of rights and protections that come with that, these are not individuals who would have been subject to Section 115 and to the usual restrictions which apply to third country nationals in this country. So when the Court of Justice says in Ibrahim and Tejera that the parent who comes in under Article 12 to create the best possible conditions for the child to attend education, when the Court of Justice says, and that parent doesn't have to be self-sufficient, that's the ratio of Tejera and Ibrahim. They continue to have, as they have always had, they continue to have a right to access social benefits under UK law, but they are not in the same position, we would say, as the third country national who overstays, who is here illegally, who's subject to Section 115 of the 1999 Act, and who then, as a result of Zambrano, acquires a right of residence. And one can go through a range of other different EU law rights and say, well, it looks a bit like that, it looks a bit more like that, but each of them has different origins, different attributes, and different consequences in EU law, and it's simply not, we say, a permissible exercise for the court to engage, in which the court should engage to try to identify a similar right and then say, well, the social benefit should be similar as well. So that's Ibrahim and Tejera. Paragraph 40 of our case, we deal with the recasting of the argument as discrimination against the children. We say that doesn't help, and certainly if we're out of scope of the charter, it certainly doesn't help to recast it as a claim by the children. And we have a number of further points in paragraph 41, including paragraph 41 sub 2. Well, is there actually treatment? See the table. And then 41 subparagraph 3 of the printed case is the reverse discrimination point. And here, as a matter of EU law, the position is, and I think Mr. Dabble accepts, the position is that EU law does not prohibit reverse discrimination, as it's called, whereby a member state treats its own nationals less favourably than it would treat nationals of other EU member states. Now he says, well, Advocate General Sharpston suggested in Zambrano that should change, and it is true that she did suggest a limited change to the position on reverse discrimination. That's paragraph 145 onwards of her opinion, MS 1792. But the only point I'd make about that is it was a limited change that she was proposing, and if you look at the criteria that she said would have to be satisfied, they wouldn't be met in our kind of case anyway. But the further point Mr. Drabble had was to rely on Miss O'Brien's article, Bundle 5, tab 82, where she says, well, this is not a reverse discrimination situation at all, because the Zambrano children are within the scope of EU law, and that's 2873, I think was where he took the point from. And her reasoning, she says on 2873, Zambrano children are within the scope of EU law. 28, and the reason why she says that, at the top of 2874, she says that they're also comparable to Ibrahim Tejera because they are exercising an EU citizenship-based right to reside and so have a claim to full equal treatment. And she says much the same thing 2 paragraphs further down. The Zambrano children are exercising an EU citizenship-based right to reside. Well, they aren't. And she's completely wrong about that. The right to reside of the children in a Zambrano case is the right of abode in Section 2 of the Immigration Act 1971. That is the provision which confers upon British nationals the right to live in Britain. See Patmal Nietzsche, paragraph 26, MS 1165, if one needs authority for that. That is not an EU citizenship-based right of residence. It is a domestic law right.
But the reason why the Zambrano carer has the right to reside is to protect the rights of the children to reside within the territory of the EU.
EU, yep.
Absolutely. So the children's rights to reside within the territory of the EU are involved.
Well,
their right of abode in the UK is domestic law for what they've got.
Well, the children's rights are certainly involved, but the children are not exercising, as British nationals living in the UK, they are not exercising an EU-based right of residence. They're exercising a domestic right of residence. Should they move to a different country of the EU, then it would be different. They would be exercising an EU law right of residence. But it is their carer whose right in the UK is an EU law right. The children are exercising a purely domestic right.
But the reason, as I said before, the reason the carer has the right is in order to protect the rights of the children.
Yes.
To remain as EU citizens within the territory of the EU.
Yes.
Now, you can say that the children are not exercising that right. We can chop logic about that. But that's the reason why the carer gets the right.
Yes, my lady.
If it weren't for the children, there would be no such right.
That's all entirely right. But that doesn't make Miss O'Brien's point for her that the children should be regarded as being within the scope of EU law. And it's because they are exercising an EU law right of residence. It simply doesn't follow in our submission. But the bottom line is this argument that member states ought to be prevented from treating their own nationals less favourably than other EU nationals in certain situations is one which has been rejected time after time by the Court of Justice, which would have helped someone like Mr. Imaraga if it had existed, but it doesn't. And we then go on to justification. If we're wrong about all of that, justification is paragraphs 43 onwards of our case. And we identify legitimate aims, 44, and in particular we rely upon the reasons set out in the statement of Mr. Cooper. So if one looks at Roman 1 on page 143, MS 143, page 23, the regulations reflect and respect the limits of the Zambrano right. Now, obviously, if you find against me on the first argument of Mr. Drabble, then that's wrong, and we lose. But assuming that I'm right about that and we get to discrimination, then the regulations do reflect the ambit, the boundaries of the Zambrano right. And Mr. Cooper is right to say that the government has sought and has achieved the objective of going no further than EU law requires. The next point is the maintaining the status quo, Roman 2. And again, it is a very important point we submit in relation to justification in this case, that the regulations did seek to maintain the position as it has always been for third country nationals, even third country nationals with British children. And that's made perfectly clear in the explanatory memorandum that that is what the regulations sought to do. And the position as it has always been is not challenged, is not said to be unlawful. So that was my third proposition that I made at the outset of my submissions. Well, how can it be unlawful to make regulations to confirm that something which has always been lawful shall continue to be? Roman 3, over the page, without the regulations, there would be, we say, very substantial anomalies between Zambrano claimants in this special category and third country nationals generally, the near-miss Zambrano claimants, for example, in the examples that I've given, or certain EU citizens would be worse off. A non-economically active EU citizen would be worse off than a non-economically active Zambrano carer. Why should that be?
Well, that's why I asked you whether you thought that was a good comparator. I mean, you weren't very keen on indicating that you agreed with that proposition.
Oh my God, I'm sorry. I wasn't aiming to be not keen. I was aiming to identify the best possible.
You were aiming to be
comparator.
keener on something else.
Yes, but certainly I do say that it would be anomalous if the third country national who, because of all the legislation that I've shown you, has no equal treatment rights in general under EU law, if they should be in a better position than an EU citizen who does have equal treatment rights in various situations. Roman 4 is the immigration control objective, and I mentioned Agiaco earlier today, which is the similar objective in the context of people with no children. And then Roman 5, this is a point we haven't really touched on so far, is Appendix FM. Well, you've got, first of all, the Section 17 support, which prevents, if need be, destitution and being forced out of the country in that way. But then Appendix FM, we say a bit more about it in paragraph 14 of our case. This is the part of the immigration rules, which formalises the route essentially for applying for leave to remain on family life grounds, and there's a section for partners and there's a section for parents. You have Appendix FM in tab 40. You have in tab 81 some guidance, which I wanted to show you, except it's the wrong guidance. Sorry about that. We have the right guidance to give you. And I just want to show you this because it's a convenient way of explaining what Appendix FM does.
We seem to have spent an awful lot of time with Appendix FM
Yes.
in recent months.
Well, then you've spent more time than I have, and I shan't take too long about it. But the point, I'll point in a moment.
Is it this? August. Thank you.
This is the one.
Now, what it does is to provide a route for a parent essentially in a Zambrano situation to obtain leave to remain on the basis of the relationship with their child, and to get it with recourse to public funds, in which case they won't be affected by the regulations that you are concerned with.
I think the real question here is whether, if somebody is in receipt of Section 17 Children Act support, they're going to come within this. So could we major on that, perhaps, Mr. Coppell?
Yes, so that bit, so assuming you satisfied, well, actually, can I just show you page 6, say explicitly, this is the guidance to decision makers. Explicitly, page 6, this is to do with Article 8, this is with Article 8, and the duty to promote the welfare of children and respect the best interests of the child. In terms of circumstances in which one is allowed to or gets leave with recourse to public funds, you have to start at 37, page 37, paragraph 7.3. The general position is that the grant of leave for the parent with the British national child is no recourse to public funds unless satisfactory evidence is provided they are destitute or particularly compelling reasons relating to the welfare of a child or parent in receipt of a very low income. And see further section 13, page 67. And the criteria are at the top of 68 in terms of destitution, compelling reasons, and definition of destitution 13.3 on 68, and then on 69 there is a paragraph in the middle of the page on section 17, support amongst other things. So what is said is that the receipt of section 17 support does not in itself evidence destitution, but will be a relevant factor, and at the end of the paragraph, an applicant in receipt of local authority support may or may not meet the criteria set out in this guidance depending on their circumstances. And there are circumstances in which the decision maker may reach a different conclusion from the local authority on destitution. So there is a route to acquire leave to remain with access to benefits in circumstances where the claimant is living in very in straitened circumstances as they're set out. And that is the route under which explicitly family life and the best interests of the child are to be safeguarded. And I've no doubt there are lots of cases that come before the first tier tribunal about the interpretation, what's destitution, what's the best interests of the child. In the usual way, some of them get as far as this court, as in Aguiarco on Appendix FM. But that is a route which is available and which meets those overall obligations. So I was on justification. The only other points that I wanted to make about justification beyond what's in paragraph 44 of the case are these. Just a couple of comments on Mr. Drabble's case. The first comment is he says that the Zambrano carer is in a distinct and unique position because they have no choice but to remain in the UK. He said they cannot leave, or else their children's rights to live in the EU will be frustrated. Well, it is right that if HC were to choose to return to Algeria, then her children would no longer be exercising their rights as EU citizens. But that is a choice which is available to her. She is not prevented, and Zambrano carers are not prevented from making that choice. The fact is, and for perfectly understandable reasons, the fact is that none of them make it because they prefer to be in the UK on the regime that exists here. And the only other comment on justification is that Mr. Drabble's case does rest on impossibly fine distinctions. When we go back to the table and we go back to the near-miss cases, it is on his case unlawful to refuse benefit, unjustified to refuse benefit to a Zambrano carer like HC, but it would be lawful to refuse benefit to somebody in exactly the same position as HC, except where there's another parent who's a viable carer, or somebody who could go and live in a different country of the EU. And of course, one can construct a legal argument as to why they may be in a different position, but as a matter of substance, it's a very fine distinction on which to rest a claim of non-justification. Now, that's discrimination. The other charter point, which I'll address while I'm here, very briefly if I can, is the Article 24 best interests of the child point under the charter, and the best interest of the child's best interest must be a primary consideration. Understood from interchange yesterday that Mr. Drabble may be resurrecting a freestanding challenge based on Article 24 of the Charter, which is the challenge that was run at first instance by Miss Mountfield, was rejected and was not appealed. That is not a claim which is before this court. And we had a permission hearing to decide exactly what claims were going to be before this court. The grounds of appeal were revised after that hearing. MS 53, they don't include this. And there is no principle of EU law which says that a party should be allowed to run arguments which they have lost on and haven't appealed. In fact, the case law is to the opposite effect. So although Lady Hale put to me yesterday, well, the court wants to get to the right answer, well, in my submission, the duty of the court is to get to the right answer on the issues that are properly before it, and not on the issues that aren't. Now, there's another way in which this Article 24, and whether freestanding or as a facet of justification, there's another way in which Article 24 is fighting a battle which is long finished in these proceedings. And it's this, that at first instance and in the Court of Appeal, the claimant challenged the regulations on grounds of breach of the public sector equality duty. And she argued that the decision makers had failed to have due regard to the impact of the regulations on children. Of course, because they primarily apply to lone parents with children, that's Zambrano carers, it was said that they have a particularly harsh impact. That impact had not been properly assessed and taken into account, therefore breach of the PSED. Rejected by Mr. Justice Supperstone, paragraph 73, MS 254, appealed to the Court of Appeal, rejected by the Court of Appeal, paragraph 118 to paragraph 122, MS 217, not appealed to this court. Now, the effect of that of the PSED claim not being pursued to this court is that you don't have any of the materials before you, including original equality impact assessments, revised equality impact assessments, which were completed in 2014, which reviewed the impact of the regulations. You don't have any of that material before you, which one ought to be referring to if one was going to argue the very similar point that the best interests of the child had not been properly considered under Article 24 as compared with under the public sector equality duty. It's hard to see what really the difference is, but it's not before this court. You don't have the materials, you don't have the submissions, and it's just too late for that to be resurrected. Now, if I have to address Article 24, the impact of Article 24, I would make these short points. As a matter of EU law, Article 24 plainly does not prevent member states from making social benefit entitlement dependent upon the residence rights of the claimant, even though that will result in some families with children not being able to claim. See Bray, Dano, Alimanovic, Garcinieto, Commission against the UK on child benefit and child tax credit. It's one thing to say that the best interests, this is Chavez, the best interests of the child should be taken into account when deciding if it is realistic for him to live with his other parent. That's one thing. It's quite another thing to say that the amount of state support which should be received by a family must also be tested on the grounds of what's in the best interests of the child. And that is a proposition which one sees nowhere in the Court of Justice authorities. Secondly, and a related point, it's really, for that reason, it's difficult to regard Article 24 as a useful standard for judging the power of member states to regulate benefit entitlement. It will always be in the best interests of the child for the parent to receive more state support. At best, what Article 24 is, and what Article 3 UNCRC may be also, is a relevant consideration, maybe a mandatory relevant consideration in certain circumstances. But there are other plainly relevant and important considerations, such as those set out by Mr. Cooper in his witness statement. And we have had the argument in the lower courts as to whether the interests of lone parents and children were properly considered in the light of all of those other objectives and policies. third point on Article 24, and these points are all equally applicable to Article 3. These points are all applicable to Article 3 UNCRC if we need to go there. The key...
Well, are you telling us that it's very, very unfortunate that we don't have all the documents related to the public sector equality duty complaint, because they would have shown us quite clearly that whoever decided on this policy had asked themselves what the impact on the duty to safeguard and promote the welfare of the children involved was, and had reached the conclusion that, and had thought, well, given the Section 17, there's no problem. Is there anything within government which said, given the Section 17, there's no problem?
What the impact assessments did was to consider explicitly the fact that these regulations would impact directly and indeed specifically upon lone parents with children and the implications of that, but to put that against other relevant considerations and decide to make the regulations nonetheless. Now, one of the, if I just expand upon that, this was my third point, one of the key considerations for the lower courts in rejecting the PSED challenge, and which is
how
relevant.
can we deal with this? Either we have the issues before us, in which case we need all the material, or we don't. Your case is that the issues we have, that you have to meet, are the ones defined in the amended grounds of appeal, which were produced following a hearing at which I was not involved. But if that's the position, then shouldn't we stick to that?
Yes. Well, Lord, I'm making these points for two reasons. Firstly, in case that position doesn't find favour with the majority of the court, and secondly, because similar points apply to Article 3 UNCRC, which would also be a new point if we're going to look at that.
I mean, this is always the trouble in these cases, that all these points can be brought in, and you can spend your time wading around in lots of different ways of putting the same point. But we're here dealing with certain fairly specific issues which have been identified very helpfully by the parties, and your position is that's what we should stick to, isn't it?
Yes. Lord, yes. And
I just say that I intend to stay with my printed case. That does include the best interest point in relation to justification. It has done since I drafted it. It's been there all the way through.
yes, I think it's Article 24 is a. I'm not sure that was there, but anyway, it's the. Let me just finish with these short points. I've got two more. They won't take long. The key and important consideration for the lower courts in rejecting the failure to consider children and so forth challenge was that the purpose of the regulations was to maintain the existing position. This was a no change policy. It wasn't a new policy, it was to ensure that things stayed the same. And that then dictated the extent of the consideration the extent of the regard which had to be had to these other considerations, and we say rightly so. And finally, on best interests, it's Appendix FM. It's explicitly there to give effect to best interests of the child. That is a route which is open to most, if not all, Zambrano carers to look at, and that is where, if I need it, that is where these matters are explicitly to be dealt with. ECHR. The ECHR has had little emphasis in these proceedings so far. The reason for that is because Mr. Drabble accepts that the general position for third country nationals and the position prior to these regulations were ever thought of is that that they are excluded from mainstream benefits by section 115, he accepts that that is lawful, was lawful, is lawful, and he doesn't challenge it. Now, it is open to him to argue as a matter of EU law that things change, that Zambrano changed things as a matter of EU law. He says brings with it an automatic right to benefits or brings with it a charter right. I understand that, but in ECHR terms, nothing has changed. Nothing has changed. And if he accepts and doesn't challenge the position as it was before and as it is in relation to most third country nationals even now, then he simply doesn't have a case on ECHR challenge to these regulations. And that is why I think he does deal with the convention in his case, but don't blink or you might miss it. Now, a number of the points I have dealt with under discrimination and justification in the context of EU law. The ECHR claim, we say, faces additional difficulties apart from the obvious one that I just mentioned. Now, first of all, which provision of the ECHR are we dealing with here? Mr. Drabble says it's Article 8, and he relies upon a bare finding in paragraph 49 of MA in the Supreme Court. And I say a bare finding because there is no reasoning in MA as to why it's Article 8 in circumstances where the lower courts had found that it was A1P1. The settled position, we say, is SG, benefits cap case in the Supreme Court, which is that Article 8 doesn't confer a right of access to welfare benefits, so one is looking at A1P1. In SG, and departing from the Court of Appeal in SG, we have Lord Reid at paragraph 79 to 80, Lord Carnworth at 98 to 99, Lord Hughes at 139, and Lady Hale at 157, all analysing the case as A1P1, and in the case of Lord Reid and Lord Hughes explicitly rejecting the argument that it was Article 8. Now, there is no indication in MA as to why Lord Toulson, with whom other members of the court agreed, considered that it was Article 8 in that case, and it may be something to do with the particular facts of that case. But we say settled position is A1P1, not Article 8.
Was it in dispute in that case? I don't remember it being an issue, but I mean.
Well,
but
Lord,
I may be wrong.
What wasn't in dispute was that Article 14 was engaged either by one route or another.
Yes.
What is hard to work out is why Lord Toulson went for Article 8 when the lower courts had gone for A1P1. I can't answer that, but it's reasoned out in SG, and we say that's the settled position. And that does affect, and again this is SG, does affect the relevance of Article 3 UNCRC, the rights of the child. We're dealing with the property rights of the mother, not the child. It's the mother's right to benefit, A1P1, and extensive reasons given in SG as to why Article 3 is at least less applicable, if applicable at all, in those circumstances. Test of justification under the Convention. It is more difficult, my submission for Mr. Drabble, to succeed under the Convention. It's the manifestly without reasonable foundation test. And that again, well, SG, Lady Hale at paragraph 210, MS 1252, and Lord Toulson in MA, paragraphs 30 to 38, MS 1282. Question is whether the justification advanced by the Secretary of State, Mr. Cooper in this case, is manifestly without reasonable foundation. I'm aware, of course, that in A and B, recently my Lord Wilson opined that that test applied to some bits of the proportionality analysis and not others. A point which wasn't argued between the parties, at least in that case. We say the settled position for benefits cases prior to A and B, and I don't want to make detailed submissions about A and B at this stage, but the settled position for benefits cases is SG and MA. It's the whole justification to which the manifesto without reasonable foundation test applies. It's not clear that it matters in this case because Mr. Drabble's objection to our justification, as I understand it, is put at the level of legitimate aim rather than fair balance, rather than pure proportionality. But if I need to say more than that about A and B, I would have to do it in writing. I can't do it today. The same detailed list of justifications apply under the ECHR as apply under EU law, plus one more. And the one more is that where a particular form of discrimination has been held to be lawful as a matter of EU law, the Court of Human Rights regards that as a strongly persuasive indication that it is also lawful under the Convention. And that is STEC, Bundle 5, and I actually don't need to take you to it, but Bundle 5, Tab 80, Paragraph 58, MS 2798, strong persuasive value afforded to a judgment of the Court of Justice in that case. Now, in our case, of course, if I'm right, well, you will have, it will be you who will have found, as a matter of EU law, that the regulations are lawful. That is then a strongly persuasive indication that they are also lawful as a matter of the Convention, and that shouldn't be surprising. And I also rely and emphasise in the context of the Convention, Appendix FM, that's what it's there for, to deal with Article 8, Article 3, CRC. As to Article 3, CRC, if we have to go into this as a matter of Convention law, I've made my points in relation to Article 24, best interests, and the same for points as I made in relation to that apply here also. There are certain additional points which apply in relation to the Convention. The first point is the A1P1 rather than Article 8. I made that point already, and what room is there for application of Article 3 given that sort of claim for discrimination. Second point, well established, appears from SG that Article 3 CRC does not displace the STEC test. And the STEC test has been applied without reference to Article 3 UNCRC in a number of cases, including where Article 3 might be thought to have had some relevance. And just one example is the Humphreys case on splitting of child benefit, which is of course the origin of the later adoption by the Court of Appeal and by this court of the not manifested without reasonable foundation test in benefits cases. Not a point of relevance in Humphreys. Third additional point, when one is considering Article 3 UNCRC in the context of the Convention, one is doing it because it is important, and the Court of Human Rights does so in certain circumstances, to take into account the international obligations of the UK. And there's an international obligation under the CRC, which is in certain circumstances of some relevance to justification. But we say that one has to take into account the full range of the UK's international obligations, including its obligations under EU law. And of course that's the bulk of this case, and if we've got this far, I will have established that the UK is not in breach of its obligations under EU law, and that is relevant. But at best, we say Article 3 is one factor among many in the Convention analysis, and it is not an answer, it is not a solution which gets Mr. Drabble home under the Convention any more than Article 24 is under EU law. And my final section is on the question of reference to the Court of Justice, or the final comment I wish to make. We say this is not a case for reference to the Court of Justice for two reasons. Firstly, because there is simply no need on issues 1 and 2. The Court of Justice has already ruled in a number of relevant cases, both as to the limited ambit of Zambrano and as to the scope of the Charter and the meaning of implementation of EU law in Charter terms. And on those issues and on others, we say this case is simply, we say it's not arguable as a matter of EU law. It certainly doesn't, say, meet the standard which needs to be met for a reference from this court. And the other point is on justification. So far as EU law discrimination is concerned, the settled position is that whether domestic legislation is justified is a matter for the domestic courts to decide and not for the Court of Justice. And that is what Lord Hope said in Patmar Nietzsche, paragraph 37, bundle 1A, tab 11, MS 1169. Actually, perhaps I'll go to that. Bundle 1A, tab 11.
Which paragraph?
I'm sorry, paragraph 37. Sorry. Paragraph 37. So this is his section dealing with justification of the right to reside test. And at letter G, he says there are two questions that need to be addressed. First, the Secretary of State's reasons for the difference in treatment provide an objective justification for it. Secondly, if they do, is that justification based on considerations that are independent of the nationality of the persons concerned? jurisprudence of the Court of Justice has consistently shown that these are matters for the national court to determine. And one very often sees in Court of Justice judgments the court setting out principles that apply to justification and then saying, well, what the answer is, whether the particular national rules at issue are justified or not, well, that's for the national court to decide. We say there aren't any difficult principles here. If you get to justification, the principles are clear, the tests are clear, you've got our case, you've got what we say, and it's for you to decide.
On the first point, the earlier point you mentioned, is the question not whether the EU issues are Act Clare or not?
Yes.
That is the question.
Yes, I'm sorry. The point I was making, and perhaps it was an unnecessary flourish, was not only are they Act Clare, but Mr. Drabble's case is not arguable as a matter of EU law. But we say the points are clear and certainly clear enough for you to decide. Those are my submissions, unless I can assist further.
I think we've probably asked you everything that we need to ask you, Mr. Coppell. Thank you very much. Mr. Rogers, is there anything you wish to add? Mr. Drabble.
My lady, my lords, can I start with my learned friend's table, because it forms a convenient basis for making some submissions. My learned friend's table effectively invites, and I certainly invite the court, to consider the position of the people in box 1, that is the British national parent and the British national child, as compared with the people in the last box, which is box 6 or whatever it is, anyway, the last box, is Zambano, third country national parent and the British national child. That's the obvious comparison. Any claim for equal treatment in an EU context will normally be an assertion that the EU national is being discriminated against in comparison with the national of the home state. And that is the obvious comparison. As we have, court has discussed, the individuals in boxes 3, 4 and 5 are all in very particular situations, and there are very small minorities of people affected by them, and they shouldn't really change the perspective. I'll come back to that in just a second, but the basic issues have been canvassed already with Mr. Coppell. Now, my learned friend, in his inimitable style, says that I haven't made my position clear on these matters. He spent some considerable time dealing with reverse discrimination. The whole point of reverse discrimination is that it is an answer to an issue raised by the comparison of the position of the EU national child who has a Zimvano right with the EU national child who hasn't. That's the whole point of it. I apologise if I didn't have a sentence that said it quite as simply as that, but that is the basic analysis that we have put forward in the printed case. And if your ladyship and your lordship look at, I'm not asking you to do it now, but in the fullness of time, look back at 4.61 to 4.64 of our printed case, we are spelling out precisely why it is that the EU national child of a Zambano carer can assert a case of discrimination in comparison with the EU national child of a UK national resident in the UK, in other words, the final box compared to box 1, why it is that is a sustainable claim, despite the comments that my learned friend makes on reverse discrimination. And we do say that Charlotte O'Brien got it dead right in the article because there is the EU national child of a Zambrano carer is in a position which is not a wholly internal situation, as paragraph after paragraph after paragraph of the cases I took the court to yesterday afternoon makes clear. Simply not a position or dealing with someone who hasn't exercised a right of movement or is in a purely internal situation, because the Zambrano carer and the British national child are not in a purely internal situation. That's the whole driver of the analysis. And we've said that repeatedly, and it's the basis of our discrimination claim. So we say straightforward comparison between the British national child of the Zambrano carer and the Zambrano carer themselves compared to the British national and the British national child. Last box and first box. The other boxes are all a bit odd. Well, the economically active EEA national isn't. That's a straightforward position of the economically active EEA national, whose position is regulated by Article 7 of the Citizenship Directive. The economically inactive EEA national with a British national child will normally be a Zambrano carer, unless, and a Zambrano carer's child, unless we're in the very small, sorry, let me just make sure I'm getting that right. Oh, sorry, no, you're quite right. I'm jumping from box 2 to 3. In box 2, you're dealing with someone who axiomatically can move somewhere else in the EU. They are, the parent is the economically inactive EEA national. Box 3 will almost always be a Zambrano carer unless one has the competing parent, I say competing parent, the other parent who might be able to adopt a dependency that they adopt.
Mr. Garble, it's my fault. I think you're on box 4. And can you just go back to box 3? Because you will have collected the fact that I wondered whether there was some proper comparison with box 3. So what are you saying about it? Because there was some confusion.
Yes, sorry, let me. What I'm saying about box 3 is it's not my preferred comparator, because my preferred comparator is box 1, the straightforward British,
I know it is.
British national. Box 3, if there is a straightforward reason in the structure of EU law as to why there would genuinely be no entitlement, namely the ability of the economically inactive EEA national parent to move elsewhere in the Union without adversely affecting the EU citizenship rights of the British child. Going back to my Lady Hale's point about what residence rights are being used by the Zambrano carer's child, they may well not be UK rights of abode. I don't mind about that one way or the other. They certainly are EU rights of abode, and they're not affected by the denial of entitlement in box 3. I hope that's a satisfaction. I hope I've got that right. Box 4, we have a third country national with no EU law rights. Now, that only arises in a situation, as we have discussed, in a situation where the third country national would be a Zambrano carer, but for the ability to move elsewhere within the Union or someone else who might take up care. So it's a very, very small minority, and we say it just doesn't and shouldn't distort the basic analysis. And exactly the same is true of the next box, box 5, because we're only interested in the first sentence of the entitlement box. In the UK, no entitlement, unless indefinite leave to remain or exceptionally limited leave with recourse to public funds. That group of third country nationals within the directive of the British national child will almost always be Zambrano carers for the same reason as we discussed in box 4. And frankly, the issue of what else happens elsewhere in the Union is irrelevant. And as we know, in a large number of, or we know in Spain and the Netherlands elsewhere in the Union. They get their benefits anyway, but as we've explored the matter of domestic law. And then we're at box 5. So we're left, that's my comment on the boxes, and my straightforward comparison is the position of the British national parent and British national child compared with the Zambano third country national with a British national child. If one focuses on the position of the child, I say focus on both, but if one does focus on the position of the child, there is a very straightforward contrast, very straightforward piece of discrimination, I would say, which needs to be justified compared to the British national child in a family where the parents are British nationals. And that's where the equal treatment doctrine comes into play and how it should be applied. So going back there, so that's my comments on the table. We now need to fit all that into, first of all, the first way of looking at it is precisely what does Zambano decide, and is there a referable issue about the application of Zambano to entitlement to social assistance benefits. We'll go back to paragraphs 42 to 44 of Zambano. Tab 24. I repeat my submission that what Zambano actually decides is that there is a right to, there is an entitlement to the grant of a right of residence to someone in the Zambano position. It's the first sentence of paragraph 43, read together with 44. So the limit of what Zambano decides is that there is a right to a residence, a right of residence, in circumstances where the refusal of that right of residence would lead to departure from the European Union. It is silent on the question of entitlement, wider entitlement to social assistance benefits. Is it arguable that there is a wider entitlement? Answer, yes. We know that in Spain and the Netherlands, the law works in that situation. We say our analysis is compatible with Ibrahim and Texier, and I'll come back to that in just a moment. And thirdly, there are other clues as to what is meant within paragraph 44 by the concept of having sufficient resources. We've concentrated so far in the case on the fact that on the first sentence of 44 must be assumed that such a refusal would lead to a situation where those children would have to leave the territory of the European Union in order to accompany their parents. Similarly, what parent not granted risk not having sufficient resources. That's the concept. And so we say that that is at least a powerful clue that what Zambano is contemplating is that there will be an EU obligation to provide sufficient resources. Does sufficient resources mean, is that obligation met by a system with the characteristics of Section 17? And we've seen Section 17 and the Southwark case. We say it's at least strongly arguable that it isn't. If your Lordship, my lady, pick up, for example, the Citizenship Directive to see what might be meant by sufficient resources in this sort of context, we'll find it at Bundle 1A, MS 1073. Well, 1073 is the provision I actually want. We're actually dealing with Article 8 of the Citizenship Directive. Which defines the concept of sufficient resources with Article 7.1b. of the directive, which is 2 pages earlier at 1070. So you have a residence right if you have sufficient resources not to become a burden. C71B. What are sufficient resources? Well, they cannot be more than the basic social assistance requirements. If you read 8.4, member states may not lay down a fixed amount which they regard as sufficient resources, but they must take into account the personal situation of the person concerned. In all cases, this amount should not be higher than the threshold below which nationals of the host member state become eligible for social assistance. So it's preventing, it's the other way around, it is preventing member states from insisting that economically inactive EU nationals have more than social assistance. But it's a strong pointer that when the court talks about sufficient resources, it's dealing with orthodox social assistance systems. As one would expect, to be honest. One wouldn't expect it to be dealing with emergency Section 17 type support. And at its very lowest, there is certainly no case which comes anywhere near to holding that it's sufficient to discharge the obligation which we say is inherent in Zimbabwe to have a system like Section 17. Now, my learned friend says our whole exegesis of what is meant by a right of residence built on Ibrahim and Texera is wrong, because underlying Ibrahim and Texera is a UK right of residence, the right to reside test, so that the analysis goes, if the UK had wanted to reverse the practical result of Ibrahim and Texera the day after the Luxembourg judgment, it could have done so by changing the right to reside test and disqualifying the future Mrs. Ibrahim's and the future Mrs. Texera's from benefit. Now, I can't say as a matter of formal analysis that that is obviously wrong, but it is a terribly good litmus paper test as to whether the analysis is correct in the first place. One goes back to Ibrahim at bundle 1C. It's 1561 within 1C, manuscript stick number 1561. Paragraphs 50 to 52. And the court can see those 3 paragraphs. We looked at them, or my exposition of them in our printed case yesterday. And you will see, for example, at 52, it must be stated at the outset there is no such condition in Article 12, that is, no condition of self-sufficiency. In Article 12 of 1612-68, the court already held that that article cannot be interpreted restrictively and must not be, under any circumstances, be rendered ineffective. Now, the idea that the explanation of Ibrahim and Texera is a domestic right of residence is, in my submission, unlikely. I'll just be polite about it, unlikely. The idea that the UK could have reversed the result of Ibrahim and Texera by changing the domestic rules on right of residence is improbable. And so if one wants to know whether there's something referable to Luxembourg, a referable issue, then that's the sort of perspective that I ask you to bear in mind. I think is all I wish to say about that. So can I then go back to the discrimination point? My learned friend's first defence to the discrimination point is that we're not implementing EU law, or the UK is not implementing EU law at all. But with respect, he hasn't got an answer to the argument that we've put forward, that if one looks at Dano, which is the case he relies on in his printed case for this proposition, one does indeed only get to the answer to question 4 once the court has said that there is no EU law right to grant social assistance to economically inactive EU citizens, such as Mrs. Dano. That's just the analysis. If one asks the question that I think inevitably comes to mind, is someone who is economically inactive but is entitled on the basis of the various directives, someone in respect of whom EU law is being implemented, the answer must be yes. It's not the question of social assistance always being outside the scope. It's outside the scope. Once it's established, there is no obligation to pay it. That is not this case. For the reasons we set out in the note. And exactly the same point about the ADA at paragraph 80. So if we just ask the court to pick that up for a moment, bundle 4. Tab 69, paragraph 80 I want, which is at MS 2531. This is a classic case, in line with our analysis of Dano, where it was established that the condition for the grant of a right of residence, a residence card, provided for in the secondary EU legislation had not been met, and there was no obligation beyond that in EU law. And your lordships of my lady can see that from the fifth line. Main proceedings is not governed by European law since he does not satisfy the conditions for the grant of that card in accordance with Article 10 of 2004-38. That's the direct equivalent of a failure of Mrs. Dano to meet the conditions of the secondary legislation in the earlier paragraphs before you get to the answers to question 4. I think it's paragraph 71 to 73 or whatever. It is all of a piece. If it's quite clear there is no obligation owed under EU law, then there is no implementation of EU law. But if there is, the converse follows. And that is precisely what we have said in the note. My learned friend had a short point about the case in Commission in the UK, dealing with whether the obligations under 88304, which is the Social Security Harmonising Directive, created a right to benefit, or were simply indicating the subject matter of the provisions. Answer the second. That, in my submission, takes, for the very same reasons I've been putting forward, takes the analysis no further forward. Now, finally, I just want to say a word about justification. Well, no, actually two things. First of all, on the question of if one is looking for a moment, I'll come back to justification in a moment, if one is looking for a moment at the scope of the EHR, the convention rights, then in my submission, it is not possible to say that the reliance on Article 8 in Carmichael is adventitious. It comes, as it were, after a very long process of debate about whether in social security one needed to rely on Article 8 when Article 1, Protocol 1 was available. And as I see a whole series of cases going right back to Steck and RJM about how you analyse the right ambit out. As I've said already, in the in the benefits cap case, Lord Dyson accepted it was Article 8 as well as Article 1, Protocol 1. And in Carmichael, Lord Toulson simply my submission, simply to put an end to the argument plumbed for Article 8.
I mean, speaking myself, I don't remember that having been an issue at all in the bedroom tax case.
That may be. That there were,
I mean, it was put under both Article 8 and Article A1P1, and I don't remember it being there being discussion about whether it mattered. I mean, in the JS case, there was a discussion, and Lord Hughes in particular took quite a strong view that it was Article A1P1. I think the rest of us were slightly more equivocal.
well, I mean,
And I remember, I was looking back, I noted that you hadn't relied on Article 8, you had relied on it was Mr. Wise who brought in Article 8.
I plead guilty to quite a lot of this confusion, because in STEC and RJM and a variety of the other cases, I didn't see that Article 8 added anything when you were unambiguously within the ambit of Article 8.
Does it in this case, does it matter? I mean, it probably does, because it's rather important to decide whether we're talking about the rights of the children, which are come under Article 8, or the rights of the parents, which are probably under Article 1.
I certainly say, as a matter of basic principle, it is Article 8 as well as, I emphasise, as well as A1P1.
Yes, I understand that.
For the reasons that I think I've already given in answer to my Lord
Yes,
Northampton.
but I mean, you're saying we're going to have to grapple with that insofar as it's left uncertain by JS.
Yes, well, can I just add one more? There's been another judgment today in the second benefits cap, where Mr. Justice Collins has quashed the second version of the benefits cap. The case is called DA and Others, against the Secretary of State for Work and Pensions, 2017 EWHC 1446 admin. You'll all find it. But he said this, in paragraph 40, I recognise it is difficult to follow why Article 8 was not relied on in SG. Well, it was raised, but as the judgment shows, was not pursued. It seems clear to me that Lord Reeve's observations cannot survive the unanimous decision of the 7 justices in MA. The bedroom tax produced indirectly the effect on private and family rights. So here the effect of the cap means that the children and their parents have restrictions on what can be provided by way of housing, food and other things that an average child should have available. Further, as the ministers have said, it may be necessary to try to move to cheaper accommodation to avoid the effect of the cap, so there will be an upheaval of the family. I set out the evidence. I am not in the least surprised that the Supreme Court in MA recognised that damage caused by a reduction in benefit will engage Article 8. Now, that may not decide it for this court.
Can you give me the reference again?
Yeah, it's DA and Others, 2017 EWHC 1446, open bracket, well, bracket admin.
Yes, and you were reading paragraph...
And I was reading paragraph 40.
Thank you.
There were some observations about best interest immediately above, 38 to 39. But obviously, that's first instance decision. It doesn't take us much further. But my own take...
But it's very useful because it puts it in context.
Yes. Yeah, my own take is that having kind of shuffled around whether Article 8 was engaged as A1P1, it was, with respect, totally sensible for the Supreme Court in Carmichael to say, well, hang on, this is just Article 8. That's what's happened. And possibly should have happened a rather long time ago, but there we go. Yep.
Thank you.
So that's the benefit, that's what's in play. Now, the justification argument fits under both the Strasbourg case and the Luxembourg case. Listen carefully to what my learned friend has said about justification. We have isolated 2 issues of principle in our printed case, which are set out as justifications for the discrimination, which we say is in play, which are set out in the witness statements produced by the Department of Work and Pensions in particular. They are, first of all, deterrence, the idea that it is legitimate to impose a financial penalty on a child who has been born for the purposes of deterring other families in the future from having children in different financial circumstances. We have a straightforward submission on the printed case that that's contrary to the best interest principle as explained by Lord Hope in ZH. We've given the references. There's been nothing back on that, no answer to that, in either the printed case or orally. And we do say that that is not a legitimate aim for either Strasbourg or Luxembourg purposes. It doesn't need to know the impact assessment or whatever. That is simply the reason why it is said that this particular financial provision has been enacted. It's the government's own explanation of it. And in my submission, it does not pursue a legitimate aim. The same applies to concentrating resources on those with the closest connection with the United Kingdom. It's not a best interest point, but it simply misses the fact that the Zambrano child is an EU citizen resident in the UK. And the whole point of the doctrine is to protect the position of that child. And we say again that reason, which is not referred to either orally or in Malone and Friends printed case, does not pursue a legitimate aim. Doesn't stack up, however you put it.
Well, the aim might be legitimate, but there isn't a rational connection.
Yes, that's probably a better way of putting it. The aim as applied to this situation is not legitimate. Yes, the aim would be, it's legitimate in the other context, as Malone and Friends points out. I don't attack other aspects of the benefits regime. It has no application here. That may be a better way of putting it. And then finally, no, not quite finally, but almost finally. In my submission, the fact that we have not attacked the regime pre-Zambrano, the regime of other secondary legislation pre-Zambrano, doesn't mean we can't now attack the post-Zambrano regime in Strasbourg terms, because something has changed. We are now dealing with people who have a recognised right, in terms of the carers, to be in the United Kingdom, and a recognised right of the child to stay here. And there's no reason at all why the ECHR analysis shouldn't change once the underlying legal position changes. And finally, on reference, we say there's plainly the issues on issues 1 and 2 are not at Clare. We say they're much more than arguable. And as to justification, there is no basis for refusing to refer on the basis of what Lord Hope said in Patmore Nietzsche, because Malone and Friends himself accepts that the issue of the principles to be applied are a matter for the Luxembourg court. And the questions that I drafted badly, maybe, and put in yesterday, are intended to raise the issue of what principles should be applied in deciding justification. We will particularly be saying that the issues of deterrence and concentrating resources contravene principles that should be applied in deciding what was an acceptable justification. So, those, I think, are my submissions, unless I'm told to say anything else, or can help in any other way. Those are my submissions.
I see no inducement to you to continue speaking, Mr. Travell, so thank you very much indeed. Thank you to everybody. We will go away and wrestle with this not altogether straightforward case and let you know the outcome as soon as we can and in the usual way. Thank you all very much indeed, and the court is now adjourned.